Many thanks, Mr Deputy Speaker, and I must firstly declare an interest as a member of Unite the Union and a prior union representative for 14 years. I rise to speak to new clauses 1, 3 and 4 and amendments 27, 28, 37, 25, 26, 24, 23, 11, 12, 13, 36 and 35 in my name and that of my honourable friends. This group of amendments covers a variety of areas in the bill that pose particular difficulties for public sector workers. SNP will focus on the new clauses on agency workers and political funds. New Clause 1 attempts to retain the ban on supply of agency workers during strikes within primary legislation. In the UK, legislation banning the use of agency workers to break strikes has been in place since 1973. The position is in line with the majority of other European countries which also prohibit or severely restrict the use of agency workers during industrial disputes. Removing this ban would be regressive and would have significant implications for all workers. Public opinion polls also indicate that changes of this nature are not supported by the majority of the general public. As such, the SNP support the adoption of the new proposed Clause 1, which aims to retain the ban on the supply of agency workers during strikes within primary legislation. Although the bill does not specifically include provisions for this to be repealed, the Government have been consulting on draft legislation which would allow this to happen. Therefore, adoption of this proposal would be a fail-safe against this occurring in the future.
Give way.
I will indeed.
I thank my honourable friend for giving way. Does she agree with me that part of the difficulty with this is that the penalties at this moment in time for an employer hiring agency workers to burst strikes is very weak indeed, and that's why we need primary legislation to be put in place to stop this practice?
I agree with exactly as you've stated, and I think it's extremely important also in terms of safety, and it's also a safety concern for the public, as I will come to discuss. Repealing the existing prohibition on hiring agency staff to replace workers participating in industrial action fundamentally undermines the right to strike. It reduces the impact of strike action and upsets the power balance between workers and employers. It is also argued that in terms of dispute resolution, it is relatively ineffective, as it serves only to prolong the dispute, delay resolution and embitter industrial relations. At a time when we are trying to encourage the living wage, it is also likely that this will drag down pay and working conditions for workers right across the country. It could have adverse implications for the agency workers themselves, as it places them in a stressful environment. Introducing inexperienced workers to take on the role of the permanent workforce in a workplace they are not familiar with also has significant implications for health and safety and quality of services. This would impact both upon those workers and also for the public at large who may utilise these services. These appear to be matters which are of particular concern to the public, with a recent YouGov poll finding that of those surveyed, 65% were against bringing in temporary agency workers to break public sector strikes, with more than half saying that they thought this would worsen services and have a negative impact upon safety. Only 8% indicated they believed that hiring agency workers during strikes would improve services.
8%.
Unlike the UK Government, the SNP believe in a modern and progressive approach to industrial relations and to trade unionism, which is at the very heart of being able to achieve fair work. We recognise that no one wants strikes, but the way to avoid them isn't to provoke confrontation by legislation, by legislating them out of existence. The right way is to pursue a relationship in partnership with both workers and employers based on respect and cooperation.
Will my honourable friend give way?
I will indeed.
Wouldn't it be better for this government to value the work of our public sector workers in particular, rather than trying to undermine the role that they do by bringing in agency workers to break strikes?
Indeed, I agree with the statement my honourable friend has made, and I would say that workers who feel valued are much more likely to increase productivity and to boost the economy. New clause 3 would provide that before the government could introduce a bill that would affect trade union political funds, they must first publish a statement specifying whether the bill was being introduced with or without agreement of all political parties represented within the House of Commons. The aim is to encourage the government to seek political consensus with other political parties before introducing legislation that interferes with unions' ability to engage politically. Unions which wish to contribute to political parties or engage in certain political activities as defined by Section 72 of TULCRA 1992 must establish a political fund. Before doing this, unions are legally required to ballot their members to ask whether they agree to the union maintaining a political fund through a political fund resolution. Clause 10 will restrict unions' rights to freedom of association and their ability to engage in political debates. These provisions will also place huge administrative burdens on unions and may reduce the level of contributions raised, as has been the case in Northern Ireland. Currently, union members have the right to opt out of their subscriptions being used for political fund purposes. They are not required to renew their opt-in. The proposals set out in Clause 10 also exceed duties which apply to companies making political donations. It is widely known that opt-in processes reduce participation. Amendment 27 seeks to remove Clause 10 from the bill completely, as it will undermine unions' freedom of association. Amendment 1 from Douglas Carswell's UKIP MP would give union members the right to direct their union to pay donations directly to a UK political party of their choice, rather than contributing to the union political fund. We are opposed to this amendment, as it assumes the union's role is simply to act as a conduit for political donations. All individuals have the right to decide to donate to a political party of their choice. Unions cannot be required by law to associate with any political parties whose values or objectives are not consistent with those of the union. I will indeed.
Thank the Honourable Lady for giving way. And of course, on the point of political funds, depending on which union you're in, for example, Unison have several political funds, going back to agreements when they amalgamated NUP and NALGO. So the legislation doesn't even take into account and COSI, of course, as my honourable friend Gated says, the legislation doesn't recognise the internal agreements which have been reached over decades.
My right honourable friend makes an excellent point, and I would also state, in addition to that, that we heard a number of testimonies from witnesses during the Bill Committee to state the very good work that unions also contribute to in terms of political donations to campaigns. Amendments 11, 12, 13 to Clause 13 attempt to limit the ability of ministers to use their powers in the bill because the powers are in breach of treaty obligations by stating powers cannot be used unless they are compatible with treaty obligations, those arising under the Council of Europe and the ILO. The cap on facility time will reduce the capacity of trade unions to represent their members and resolve disputes in the workplace before they escalate. According to the TUC, there is a risk that the proposal for a cap could conflict with EU law, which protects the rights of health and safety reps to be paid time off for their duties and training. The rights of union representatives to paid time off and office facilities during consultations on collective redundancies and outsourcing, TUPE rights, and even under general information and consultation arrangements covered by the Information and Consultation of Employees regulations. Amendments 35 and 36 attempt to limit the ability of ministers to use their powers in the bill because the powers are in breach of treaty obligations by stating powers cannot be used unless they are compatible with treaty obligations, those arising under Council of Europe and ILO. Clause 14 will prevent all public sector employers from deducting union subscriptions via the payroll. This will make it harder for individuals, including lower paid workers, to access union representation in the workplace. The TUC is also concerned that Clause 14 will only apply to trade unions and not to staff associations. This suggests that the government wants to make it harder to join trade unions and to access the benefits of trade union membership, including effective representation in the workplace and specialist advice on employment rights, health and safety and other work-related issues. Under Clause 14, the government will be able to introduce regulations imposing a ban on check-off arrangements across the entire public sector. The plans in particular to impose changes to collective agreements voluntarily agreed by employers and unions do not comply with ILO standards. The Minister, Rosanna Cunningham, made it clear during evidence sessions that the Scottish Government does not support the proposed ban on check-off arrangements. And in recent weeks, more than 50 local authorities, NHS, employers and employer organisations have criticised the Government's plans to ban check-off arrangements in the public sector. The Government claims this proposal will save taxpayers up to £6 million. However, many unions already cover the cost for check-off services, as has been discussed, and in some cases fees changed by public sector employers for check-off provision generate a net gain. The other issue that was raised during the Bill Committee was the very great concern that legal challenges to the Government could actually cost the public purse. Amendment 5, tabled by Jeremy Lefroy MP, would provide that the ban on check-off arrangements would not apply in public sector workplaces where the employer and where relevant unions have agreed. We support this amendment. In concluding, this is about people, their lives, their pay and their conditions. It's about their safety in the workplace. It deserves to be paid the utmost respect by all sides of this chamber.